All right, so let's go ahead. Judge Avery, if you want to get us started, I did, as I said, I do have a quorum. So we are ready to start whenever you are.
All right, that's wonderful. So our chair, Judge Wilson, had a conflict tonight at the last minute, and he sends his apologies. So I'm filling in for him. And I'm sorry for you all because I'm not nearly as organized or adept at parliamentary procedure as Judge Wilson, but I will do my best. Do we have Senator Casserly with us?
I don't see Senator Casserly. Unfortunately, his attendance was definitely tentative, so it doesn't look like he was able to join us.
Please let me know if he does join, if for some reason I don't notice, because I do want to recognize Senator Casserly, and I would like to say a few words about his service on this commission since 2016. And I'll hold off on that just in case he does join. But in the meantime, I do wish to welcome our new commissioners, starting with Delegate Sandy Bartlett, who has been a member of the House of Delegates since January of 2019, representing the 32nd district in Anne Arundel County. We're very excited to have you with us. Also, Senator Sidnor, who has been with us on the Sentencing Commission since 2019. Now he is a senator, and I believe that Senator Sidnor is also joining on the guidelines subcommittee. So
correct.
Yeah.
You don't actually see him on the. He is. Oh, sorry. I did know that he was not planning to attend this evening. He had other
tonight. Okay.
Right. Correct.
Great. Okay, but Senator Sidnor will be an active member. He's joined on the guidelines subcommittee, and we really value his service there. Also would like to welcome Senator Chris West, who has been a senator since January 2019 from the 42nd District in Baltimore County, is also a member of the Senate Judicial Proceedings Committee, and we welcome Senator West. And I'm looking at my screen, and I can't really see if Senator West is here, and I apologize. Is Senator West with us?
Yes, I'm here.
Okay, all right, great. Now that you speak, I see my little boxes are rearranged. Welcome.
I stopped sharing my screen. We don't really need so that we can see the full box of participants. So that'll be a little bit easier.
Okay, that's really helpful. So now I've enlarged it and I can see, I think, everyone who's in the meeting. That's a lot better. Thanks so much. All right, we'd also like to welcome attorney Kyle Schreier. Am I pronouncing that correctly?
Shearer is how I pronounce it.
Shearer. Okay, thank you so much. Who was recently appointed to the commission in August by Governor Hogan, and is one of our two public representatives on the commission. Welcome. And State's Attorney Robert Harvey, who is the representative from the Maryland State's Attorneys Association, and also is going to be serving with us on the guidelines subcommittee, and was already participating on the guidelines subcommittee when we recently met. Thank you very much for being with us. Also reappointed to the commission is Dr. Brian Johnson and Alethea Miller. We're very happy about those reappointments, and thank you for your service on the commission. Okay. With that being said, do we have a motion to approve the minutes from the July 6th meeting?
So moved, Secretary Green.
Thank you, Secretary Green. Is there a second?
Second.
All right. All in favor of approving the minutes? Any opposed? All right, so the motion to approve the minutes passes. We will move now to the guidelines subcommittee report, which I will tell you that the guidelines subcommittee did meet on September 2nd, and we had a robust meeting as usual relating to the classification of offenses. That's all I'm going to say about it. I'm going to actually turn it over to Dr. Soulé to give you more details about that meeting.
Thank you, Judge Avery. I appreciate that. Just to echo the point that Judge Avery made earlier, we do have two new members on the subcommittee, Robert Harvey, the state's attorney from Calvert County, who graciously agreed to join us. He was appointed to the commission the day before the subcommittee meeting. So he really stepped right in and was performing his duties right away. So we appreciate that, Mr. Harvey. And he replaces Brian DiLeonardo, who, as you all know, was appointed to the bench in the circuit court for Carroll County in July. And next, the subcommittee welcomes Senator Sidnor as well, who is taking the place of Senator Kelly, who, as you all know, was a member of this commission for a very long time and for the subcommittee for its entire time. So both have big shoes to fill, but we are very grateful to have both of them now working with us. So the subcommittee reviewed 3 items. The issues are presented as items 6A through 6C on the agenda for today. So I will start with hopefully the easiest one. This is agenda item 6A. This is proposed classification of previously unclassified offense. This is an action item, and I am going to turn it over to Sarah Bowles from our staff to present this item.
Thanks, Dave. I'll refer you to the memo labeled Proposed Classification of Previously Unclassified Offense. Our staff was recently contacted by a criminal justice practitioner regarding an offense not contained in the guidelines offense table. This offense carries a maximum penalty greater than 1 year. The commission's policy is to classify any offense with a penalty of greater than 1 year, and therefore this memo presents to you the previously unclassified offense, along with the guidelines subcommittee's recommendation as to its classification. The offense is listed on page 1 of the memo and is a second or subsequent violation of Environmental Law Article Section 9-204 with the penalty provision contained in Environmental Law Article Section 9-343A12, and which prohibits the installation, alteration, or extension of water supply systems, sewerage systems, or refuse disposal systems without a permit. A second or subsequent violation of this section is a misdemeanor, punishable by up to 2 years imprisonment and/or a fine of $50,000 per day of violation. Based on previously established protocol, the guidelines subcommittee offers seriousness category recommendations by examining currently classified offenses that are comparable based on the following: type of offense, statutory maximum, misdemeanor, felony classification, and nature of the offense. Comparable offenses here are listed on page 2 of the memo. Based on these comparables, the guidelines subcommittee recommends classifying this offense as a property offense with a seriousness category of 7. I would also note that Environmental Law Article 9-343 contains a penalty for a first-time violation of this act, which carries a maximum penalty of 1 year imprisonment and/or a fine up to $25,000. This offense is also not contained in the guidelines offense table, but by guidelines rule, since the maximum penalty is 1 year or less, the offense is assigned a seriousness category 7. And I'll turn it over to you for any discussion.
So this is an action item, and this was a unanimous recommendation to accept from the guidelines subcommittee. Not a highly controversial vote, I will say. So at this point, I would ask if there are any questions, concerns. We'll hear from you now. Okay, hearing none, is there a motion to accept the guidelines subcommittee recommendation?
So moved.
Thank you. Is there a second?
Second.
All right. I will ask if there are there any votes opposed to accepting the recommendation? Okay, seeing, hearing none opposed, then that would be approved.
Okay, thank you, Judge Avery. So the second item we're going to review from the subcommittee report is agenda item 6B. This is the continued review of the guidelines ranges for drug and property offenses. And Stacy from staff is going to present this particular issue. And I will go ahead and share my screen again just for this portion of the report. We thought it would be easier to have a couple slides to help guide this discussion, but I'll turn it over to Stacy, and I'll start sharing my screen here in a second, Stacy.
All right, thank you, Dave. So the materials that are provided for today's discussion of guidelines compliance by cell include staff proposed revisions to the guidelines ranges in the drug and property matrices, strict compliance rates for those proposed ranges, and a corresponding memo. These materials are provided for informational purposes only, as the subcommittee is not requesting any action by the commission at this time. The subcommittee is still considering the proposed revisions to the drug and property matrices and is not yet prepared to make a recommendation to the full commission. With that said, the staff and subcommittee thought it would be helpful, given that the compliance review has spanned multiple meetings and there are new subcommittee and commission members, that we take this time to summarize the compliance review to date. So I will spend hopefully just a few minutes doing that. So review of compliance with the sentencing guidelines is one of the commission's primary responsibilities. Accordingly, the MSCCSP periodically conducts detailed reviews by examining compliance within each cell of the 3 sentencing matrices. And those are matrices for drug, property, and person offenses. The last review concluded in December of 2015 with the commission's vote to approve revisions to the sentencing matrix for seriousness categories 4 and 5 drug offenses. And those revisions were effective July 1, 2016. The commission initiated the current review of guidelines compliance by matrix cells in the spring of 2021. This timing allowed for the collection of 3 full calendar years of sentencing guidelines data following the Justice Reinvestment Act and the corresponding October 2017 revisions to the seriousness categories for many common property and drug offenses. The review is based on data for single count cases, guidelines eligible sentencing events during calendar years 2018 through 2020. So we have 3 full years of data. So central to the review is a consideration of both regular compliance and strict compliance with within each matrix cell. So there are a number of factors that determine regular compliance. First, a sentence is guidelines compliant if the initial sentence, which is defined as the sum of incarceration, credited time, and home detention, falls within the applicable guidelines range. Second, sentences that involve no post-sentence incarceration, but fall above the upper guidelines limit because of credit for time served are also considered guidelines compliant. Third, sentences to corrections options programs are guidelines compliant, provided that the initial sentence plus any suspended sentence falls within or above the applicable guidelines range, and the sentencing event does not include a crime of violence, child sexual abuse, or escape. And finally, sentences that are pursuant to an ABA plea agreement are guidelines compliant. The data that are utilized for the current review are based on sentences that are prior to the recent name and definition changes for a guidelines compliant plea. So as such, the terms ABA plea agreement here indicate a guidelines compliant plea. So in comparison, strict compliance considers a sentence guidelines compliant only if the initial sentence, which is defined again as the sum of incarceration, credited time, and home detention, falls within the applicable guidelines range. So as a first step in the review, the subcommittee examined both regular compliance and strict compliance rates for each cell of the current matrices, with particular attention paid to cells with a compliance rate below the 65% benchmark standard and a sufficient sample size of at least 50 total cases. So the commission adopted the goal of 65% as the benchmark standard for sentencing guidelines compliance, with the understanding that guidelines revisions should be considered when sentences depart from the guidelines in more than a third of cases. So results from the first step of the current review showed that while nearly all cells currently meet the benchmark for regular compliance, more than 1/4 have a strict compliance rate below the 65% benchmark. Further, in the majority of cells where the compliance rate is less than 65%, departures below the guidelines exceed departures above the guidelines. So in short, regular compliance looks good, strict compliance, not so much. So the second step of the review considered the impact of the COVID pandemic on sentences and guidelines compliance. Approximately 13% of sentences considered for the review in calendar years 2018 through 2020 occurred during COVID. To the extent that defendants sentenced during COVID were diverted from incarceration or were incarcerated for shorter periods of time due to the pandemic, one would expect that to observe differences in strict compliance by matrix and cell when those sentences are removed or excluded. So results of the second step of the review showed little evidence of a so-called COVID discount, with few differences in strict compliance rates when COVID sentences are removed. Further, any observed differences were small, with rates generally varying by no more than a few percentage points. So that brings us to the current step, step 3. The third step of the review, which was undertaken by the subcommittee at its recent meeting, considered staff proposed amendments to the drug and property matrices and examined how compliance rates would look with those revisions. At this point, I would like to draw your attention to the summary document containing the current and proposed ranges for the drug and property matrices. And that document was provided with this evening's materials. Supplementing this summary document are the detailed tables that list the strict compliance rates for both the current and the proposed ranges. I'm not going to go through those detailed compliance tables, but I will touch on their findings briefly as I review the summary document. So if we look at the summary document, 3 rows of information are listed for each cell. The first row shows the middle 65% of sentences. In other words, what the range would need to be to capture the middle 65% of sentences in the cell, as well as the total number of cases for the cell. And I will note there are some cases where the ends are particularly small, and in those cases, we did not estimate the middle 65% because statistically it did not make sense to do so. The second row contains the current guidelines range, as well as the number of months that are below, or I'm sorry, the number of months that are between the lower and upper ranges. So how many months does the range cover? And then the third row contains the staff proposed guidelines range. And again, the number of months between the lower and upper ranges. And as with the documents that were provided in the past, cells that are highlighted in yellow have a strict compliance rate of less than 65% and at least 50 cases, while cells that are highlighted in blue have a strict compliance rate, again, less than 65%, but they have fewer than 50 cases. So to illustrate these cell contents, I thought it might be helpful to just look at an example, and David has that shown here in the PowerPoint slide. So let's consider the drug matrix cell that corresponds to a category 4 offense and an offender score of 2. The first row of the cell indicates that there are 106 sentences for a category 4 drug offense where the offender has an offender score of 2. And the middle 65% of those sentences is probation to 7.8 months. The second row indicates that the current guidelines range is 1 month to 1 year, with 11 months between that lower and upper range. And the yellow highlighting indicates that fewer than 65% of sentences are within that range. The third row indicates that the staff proposed range is probation to 6 months. And the absence of the yellow highlighting here indicates that at least 65% of sentences are within that proposed range. The specific strict compliance rates are provided in the separate detailed compliance tables that were included in tonight's materials. And I'll just briefly note by way of example here that those tables indicate that 47.2% of the sentences are within the current guidelines range, whereas 80.2% of sentences are within the proposed guidelines range. So if we shift the guidelines range to the proposed range, we get a higher compliance rate. The proposed revisions, we believe, strike a balance between a strictly descriptive middle 65% of current sentences, the number of months in each range, and the proportionality of ranges across cells. The proposed revisions move the guidelines substantially closer to the middle 65% of sentences. However, they do not correspond strictly to the middle 65%, as they offer proportional incremental increases going across the matrices as the offender criminal history score increases, and down the matrices as the offense severity increases. As noted, the yellow highlighting in the summary document gives us an indication of how the proposed ranges compare with the current ranges in terms of strict compliance. And just to summarize the revisions for the drug matrix and the property matrix briefly, if we look first at the proposed ranges in the drug matrix, the yellow highlighting indicates that there are 9 cells with at least 50 cases where strict compliance is less than 65%. And this is compared with or down from 15 cells in the current matrix. Looking next at the proposed ranges in the property matrix, the yellow highlighting indicates that there are 6 cells with at least 50 cases where strict compliance is less than 65%. And this is compared with, or again, down from 14 cells in the current matrix. So in short, the proposed ranges improve on the current ranges, moving the guidelines closer to actual sentences with proportional recommendations that are not so wide as to lack guidance. So the next step in the review, the subcommittee discussed the staff proposed revisions, which I just briefly went over, at its recent meeting in September, and decided to postpone the vote on the revisions to allow additional time for review. Given the importance of the revisions and the recent turnover of subcommittee and commission members, the subcommittee is recommending holding a special meeting prior to the scheduled December 7th meeting to permit further consideration of the proposed revisions. And I think at that point, I will turn it over to the subcommittee and the commission. If there are questions, I'm happy to answer them.
Thank you, Stacy. First, I just want to say that was a great job summarizing that.
Thank you.
So David, I don't know if you wanted to elaborate on this special meeting and maybe some of the considerations that are driving the meeting itself.
Right. No, I appreciate that. Yeah. So the idea for a special meeting was proposed really because, you know, 2 of our 4 subcommittee members are brand new to this process, and they were jumping right into it. And just given that we also have 5 new commissioners total out of 19, we really thought that it was fair and really the right thing to do to give a little extra time to make these considerations. We could have pushed it all off to the December meeting, but instead the proposal was to schedule a new separate meeting to address just proposed revisions in November. And the thinking was that would be done with the goal of hopefully potentially having proposed revisions to vote on at the December meeting. And we wanted to keep that time frame because as you may all know, is the December meeting, we also have, it's the standard joint meeting that we have where we do a partial public comments hearing first and then a regular business meeting after. So if we, by having a special meeting in November, that would allow us to specifically have time to potentially vote on them, for the commission to tentatively adopt amendments to the matrices, if that's the decision of the commission, and then to call for comment on those proposed revisions. So we would publish that call for comment on our website and in the Maryland Register, and allow for public comment at the December meeting. So I think everyone on the subcommittee agreed that that was a good and fair process that wouldn't really set us back too far. If we pushed it to December and waited to call for public comment, we don't traditionally meet in the next year until after the legislative session has concluded. So that was the idea for a public meeting. So I know this is listed as not an action item. I guess the action would be, it's not an action to postpone, but there would be an action to schedule, if the commission were to agree to this, to schedule the special meeting in November. And then I am ready to present dates that I really would like us to act on tonight and to try and lock in, with November 10th being the date. It's a Wednesday, November 10th, and that's the date that we've identified as we thought is really good. We want to stay away from Thanksgiving week. And we also need to give ourselves enough time to call for comment before the December 7th public hearing. So we kind of settled in on in the first couple weeks of November, with November 10th being the best possible date. So we might, I know Judge Avery, if you want to entertain any further discussion, whatever you're thinking here, but I would like at some point to consider if the commission to act on whether we will schedule this special meeting and then selecting a date.
Okay. Well, I don't think that we have to vote on scheduling a special meeting. Let's see. David, can you stop sharing your screen?
Yes.
Okay,
Yes.
I feel like I need to see.
No, you're totally right. Yes.
Okay, thank you. All right, so November 10th has already been a date that's vetted through the guidelines subcommittee. That's correct, right, David?
Well, it was vetted through yourself and Judge Wilson, actually.
Oh, okay.
We did go ahead and schedule a guidelines subcommittee in hopeful anticipation of having a November meeting. So we scheduled a subcommittee meeting.
Okay.
But we vetted November 10th through yourself and Judge Wilson.
Okay, well, sorry, but I thought that I was confusing it with the rest of the guidelines
That's okay.
subcommittee group. But is there any firm objection to November 10th as the date for the special meeting? Okay, speak now. Okay, then let's go ahead and go with that date. And I think what I want to say at this point is, especially with the new members of the commission, we don't have a formal orientation for new members, but you do have access to all of the material on the public-facing Sentencing Commission website. That includes our enabling legislation, that the intent talks about the intent in terms of the purpose of the Sentencing Commission, as well as some history of how the Sentencing Commission came into existence. I think this history and purpose is very important, and I think it's highly relevant to the decisions that we will be making moving forward as it pertains to revising the guidelines. I really do hope that every single one of us takes an opportunity to look at that material so that we are voting, commenting, making decisions based on an understanding of the purpose of the guidelines and how the guidelines work, that the guidelines are voluntary, that the guidelines are based on data that is provided on a statewide basis, and that the purpose of the guidelines is to provide sentencing judges, with information that relates to what sentences are being imposed for similar or the same offenses under similar circumstances by offenders with a similar criminal history. So I don't want to go on. I'm not trying to give everybody a lecture. What I'm asking you to do is to take the opportunity that we have between now and then to familiarize yourself with the fundamental purpose of the commission so that we're all on the same page. Okay, moving on then to subsection C, which is the reclassification of third-degree sex offense.
Okay. So I will refer you to the memorandum labeled proposed reclassification of sex offense third degree involving age-based elements. So the staff completed this analysis as a complement to the cell-by-cell compliance review and in response to feedback received from members of the criminal justice community. When asked for feedback regarding the guidelines, judges and other members of the criminal justice community cited third-degree sex offense as an offense in which the guidelines are too low. In response, the staff analyzed sentencing guidelines data to determine if sentences for third-degree sex offenses were frequently outside the guidelines. Given that the commission is considering potential revisions to the guidelines to decrease the guidelines ranges for the majority of drug and property offenses, the staff thought it would be appropriate to examine guidelines compliance for third-degree sex offense and to look to see if there are other offenses in which departures above the guidelines are more common than departures below the guidelines. The analysis identified 6 person offenses, 1 property offense, and 2 drug offenses, where sentences were more likely to be above versus below the guidelines. So again, that is the minority. That is a very small percentage of offenses. As Stacy noted earlier, when there are departures, they are much more likely to be departures below the guidelines than above the guidelines. Of the offenses that I noted, again, 6 person, 1 property, and 2 drug offenses, sex offense third degree involving age-based elements stood out. First, it is the offense with the highest percentage of sentences that are departures above the guidelines. Second, it was the only offense that staff identified from this analysis in which it may be appropriate to amend the offense's seriousness category based on its statutory maximum penalty. So in other words, a potential revision to the seriousness category for the other offenses that are mentioned in the memo would not be consistent with the commission's policy to make the seriousness categories consistent with other offenses that have similar statutory maximum penalties and similar felony and misdemeanor classifications. While the other offenses that staff identified did not call for revised seriousness categories because of the statutory max that's assigned, the information on the departures was included in the memorandum as it may be useful to legislative members of the commission or any other legislative members who contemplate and revise statutory maximum penalties. So we also thought it would be helpful to give a little bit of historical background regarding the commission's classification of third-degree sex offense, In 2006, the commission conducted a similar analysis and found that judges were more likely to depart above versus below the guidelines for the same offense. Accordingly, the commission at that time voted to separate the 2 acts that are covered by the statute that prohibit sex offense third degree. A violation of criminal law article section 3-307A1 or A2, which involves the employment or display of a dangerous weapon, or an individual who is substantively, cognitively impaired or mentally incapacitated, was reclassified as a seriousness category 4 offense, while a violation of criminal law article 3-307A3 through A5, which involves the age-based elements, remained a seriousness category 5. So essentially, we took the statute for third degree sex offense and we divided it out by the subsections and gave separate seriousness categories for those 2 distinctions. So that was done in 2006. Despite this reclassification, the staff's recent analysis found that judges are still more likely to depart above versus below the guidelines for third-degree sex offense involving age-based elements. In the Commission's 2020 survey of criminal justice practitioners, one judge noted that when calculating Part A of the offense score, all seriousness category 5 through 7 offenses receive 1 point. So that's a rule in the guidelines, right? Any offense that's category 5, 6, or 7, they still all receive 1 point in calculating the offense score. So that means that sex offense third degree involving age-based element, which is a seriousness category 5 offense, carries a 10-year statutory maximum, would receive the same number of points as a sex offense fourth degree, which is a seriousness category 7 offense and carries a 1-year statutory maximum. The memo, as you can see, provides data as to how guidelines compliance range would change if the offense were reclassified as proposed, specifically that the above departure rates would decrease and compliance would increase. Additionally, the memo illustrates the most common guidelines ranges for this offense when classified as a seriousness category 4 versus a category 5, which it currently is classified as. The subcommittee reviewed this issue, and there was a fair amount of discussion regarding the wide range of variability in the facts related to a conviction for third degree sex offense. For example, it was noted that sometimes the perpetrator is a 19-year-old adult male, while other times it could be a significantly older adult male. Sometimes the adult is also subject to charges of sex abuse of a minor. Subcommittee noted that if the seriousness category for this offense is changed from a 5 to a category 4, the most common guidelines range for the typical third degree sex offender, which is someone who has no prior record. When we looked at data, that's what we found out. That's the most common third degree sex offender. The most common guidelines range would still include a lower recommendation of probation. As a seriousness category 5 offense, the most common guidelines range for a defendant with no prior record is probation to probation. Were the offense reclassified as a seriousness category 4, the most common guidelines range for the defendant with no prior record would be probation to 3 years. In either scenario, the lower range is still probation, but the upper range would increase if the seriousness category were revised. Accordingly, the majority of the subcommittee members felt the revised range would give judges the flexibility to adjust the sentence based on the particular facts of the case. Based on the review of the feedback from the judges and the survey respondents, as well as the review of the sentencing guidelines data, the subcommittee voted in favor of the proposed revision by a margin of 3-1 to reclassify sex offense third degree involving age-based elements from a seriousness category 5 offense to a category 4 offense. Accordingly, I present this proposed revision as the recommendation of the guidelines subcommittee. I will certainly open it up for discussion at this point.
David, are you prepared to entertain a motion to accept the?
I'm sorry. I just wanted to make one comment while it was invited from Dr. Soleil. I think that the third degree sex offense based on age-based elements is sufficiently different from the third degree sex offense based on force or threat of force or sexual contact with somebody who has some type of intellectual disability or other mental incapacity to warrant leaving the guidelines where they are now. And the reason is that unlike those first two categories, which, as Dr. Soleil noted, in 2007 were made category 4 offenses, in the age-based sex offense based on age-based elements is different because in those cases there is no defense of a reasonable belief in a mistake of age. In the sex offense based on force or even the sex offense based on sexual contact with somebody who has a cognitive impairment, there's a requirement that the person or there's a defense based on if the person would reasonably not believe that the person had such a disability. In reading the memorandum, I immediately thought of a case in which I was the defense attorney some 20 years ago, and we lost, and it became a reported opinion in the Court of Appeals, Walker versus State, which is reported at 363 Maryland 253. It's a 2001 case. And even though it's 20 years old, it remains the law in Maryland, and it remains the Court of Appeals' last word on this statute, at least as it relates to age-based elements. And in that particular case, the court held that it's a strict liability offense, that there is no defense, no matter how reasonable the belief, both subjectively and objectively, that a person may have about the age of the victim in the case. And just briefly, the facts of the case, my client, Mr. Walker, met his girlfriend at work. He was working at a Weiss Market. And at the time, I don't know if it's true now, but Weiss Market had an employment policy that required all of its employees to be at least 17 years old. And in filling out an employment application, the victim in this case, falsified her age and said that she was above 17. She told my client during the course of their relationship that she was 19. That was undisputed. The facts in the case were undisputed by the prosecution. Despite that, my client was convicted. There was no defense, and the Court of Appeals affirmed that. And that remains the law to this day. The only difference between then and now, instead of having just the felony record, my client would have to now register as a tier 2 sex offender for the next 25 years. So again, because the age-based sex offenses based on age elements can involve such a wide range of conduct, there are certainly instances in which it's very clear that the defendant is an older person who knows that the victim is a minor. But then we have cases like the Walker case. Because there is no defense for a reasonable belief that the victim in the case is above the statutory age of consent, I think it's different. And I think it's different from the A1 and A2, which the defendant either knows what that what the defendant is doing is wrong because they're doing it by force or threat of force, or the defendant, has the ability to assert a defense on the grounds that he or she had a reasonable belief that the person was not suffering from an intellectual disability. Thank you.
David, may I speak for a moment?
Oh, sorry, I'm on. Yes,
You may.
of course.
Go ahead, Rick.
Okay, thank you. I don't know if you noticed, I was having computer issues when almost immediately after David started talking about the recommendation. So I didn't hear everything that David said, but I was the one guideline subcommittee member that was against changing this category for this offense. And so I'm not clear that David expressed everything that I had said, but I just wanted the commissioners to know that the main reason for my objection was that in 2006, perhaps about a year after I became a member of the commission, the bifurcation of this offense was a voted on, negotiated decision made by a vast majority. I believe it was a 10-2 vote or something like that to distinguish between third-degree sex offense, the A and B version, and the age-based version, C, D, and E offenses. For many of the reasons, some of the reasons that Mr. Zaremba has described, and for many other reasons, it was deemed that the character of the offense for A and B versus C, D, and E was very different, and therefore the C, D, and E age-based element offenses should not be increased, but that the A and B should be increased. It's been that way since 2006, and I appreciate that the staff gathered these this data together, and the statistic together for us to see. What was missing from what I saw, and I think is important, is how that offense is sentenced across all of the criminal history categories. Different from what we were looking at with regard to drug offenses, we have not seen how the sentencings occur across all criminal history categories for this particular offense. And additionally, we will all be addressing the persons table for further review, just as we are now presently addressing the drug and property tables for review. The guidelines subcommittee agreed to, again, bifurcate because property and drug offenses are a little easier to deal with than person offenses. So we're going to be addressing all of that in the coming months with respect to our review of the persons table. It is true that the statistics that were provided to the guidelines subcommittee support the modification of this particular offense to a 4. There's no doubt about it, just like they support, I think, the changes to the drug tables that we will be considering at our next special meeting. So my objections were based on that. If these statistics bear out exactly what the staff has shown us, I think that this offense does need to be changed and my vote would change. But it's just a matter of getting full statistics across all criminal history categories, and also a matter of consideration of the history of how we got to have bifurcated third-degree sex offense categories. That was my objection. Thank you, David.
So Judge Avery, if I could just respond to that, I understand, Rick, your point. I will just say that although we didn't do an analysis, right, that looked at the sentences across all offender scores, we did look at guidelines compliance, and that accounts for the offender score essentially. So what we know is that for this particular offense, less than 46% of sentences are within the guidelines, which account for the offender score. 2.8% go below the guidelines, and 51.5% are going above the guidelines. So that measure is accounting to some degree what you were asking for, looking at it across the various offender scores, because the guidelines, of course, are taking that into consideration. So what we're seeing is that judges with those offender scores are consistently going above the guidelines for this particular offense.
Right. So if I could make a point about that, and that again goes to what our purpose is in looking at the data and making decisions that are based on the data, but also based on feedback from from judges as well as the criminal justice community. And in this case, the point that is allotted to third-degree sex offense involving an age-based element, it gets the same point value, essentially, which has a sentence of 10 years. It gets the same point value as the 4th-degree sex offense, which has a maximum penalty of 1 year. So that just doesn't make sense. And I think that, I would just caution the members of the commission not to get lost in the details of this. There's a reason why we looked at this, because there is an obvious inconsistency in how we're treating it. But it's also important to note that even with the change, even with the category change from a category 5 to a category 4, that the guidelines include probation. The low point of the guidelines is probation at category 5, it's probation at category 4. So it doesn't affect any injustice to the type of person that I think we all want to think of as Mr. Walker, like in Mr. Zaremba's case, or the 19-year-old who mistakenly has a relationship with a minor. We know that judges are going above the guidelines, and there's a reason for that, because a lot of these cases involve much more serious offenses. And there is a reason why the legislature established the statutory line of 18 and put a 10-year sentence on it, because it is a serious offense. And we should not be categorizing it in the same way as a lesser offense that only has a maximum penalty of 1 year. So in the case where there's a mistake of age, at least the defense is put out there, even if a judge believes that there could have been a mistake of age, the judge still has within the guideline. Well, the judge can go below the guidelines, of course, with an explanation, but even within that framework, the guidelines have a probation as the base entry point. So I just wanted to make that point. That was one of the issues that was discussed in the guidelines subcommittee. Does anyone else wish to be heard on this matter? Is there a motion to accept the guidelines recommendation to categorize third-degree sex offense involving age-based elements from a category 5 to a category 4?
I think Delegate Barton's trying to speak. She's not able to turn on her microphone. She's kind of waving.
I had a question.
Oh, there you are. Okay,
That's okay.
thank you.
I had a question. I couldn't find the raise hand button fast enough because I was looking at the memo as well. But thank you, Melinda. Thank you for helping me with that. So my question was, I just wanted to make sure I'm up to speed here. The reason I kind of wanted to know a little bit. I was looking in the memo for the history as to why the age-based sexual assault offenses were down, or elements were down, or in a category 5. I understand why they are proposed to be in a category 4, but I'm not quite sure why they are where they are to begin with. If I could just get that history, it will make my vote clearer. Thank you.
Right, that's a good question. So third-degree sex offense, prior to 2006, there was no separation out by the various elements of the statute, right? So third-degree sex offense of any kind was a category 5 offense. So just to take a step back, when the commission classifies offenses, and this is good information for new commissioners, what the commission typically looks at is comparables. And so we'll look at other offenses that have a similar statutory maximum penalty. So in this case, 10-year statutory max, the felony misdemeanor classification, what type of offense it is, if it's a person, property, or drug offense. And we'll look at comparables. So, because the whole point of guidelines is consistency. So we want the guidelines to be similar for similar offenses based on those variables, statutory maximum, misdemeanor, felony classification, et cetera. So prior to 2006, it was a category 5 offense. That was one of those offenses where it was probably on the offense. It was on the fence, right? It could have been a 5 or a 4. There's more category 4 10-year statutory maximums than there are category 5 10-year statutory maximums. So the commission at the time wasn't necessarily willing to take all third-degree sex offenses down to a category 4 offense. But what we did was we looked at the same data at the time. We didn't have it separated out. So we looked at it and said, okay, well, judges are departing above the guidelines. And the theory was that it probably was because for the subsections A1 through 2 involving force, that it was probably those types of third-degree sex offenses where judges were giving out higher sentences. So we assigned a more higher seriousness category, a more stringent seriousness category, a 4, for that specific section of the statute. And then we started collecting data on it moving forward. So now we here are, in 2021, we have multiple years of data on it. And what we found is that what we theorized in 2006 wasn't really completely accurate, because judges are seemingly giving higher sentences for both the age-based elements offenses and for those involving the non-statutory portion of 3-307. So that was a long-winded answer, but I wanted to kind of give you a little bit more of the background. So it was a 5 to begin with. We took a portion of it and made it a 4, and now we're the proposal on the table is to make the age-based elements a 4. If you look at page 7 of the memorandum, which is the last page, you can see that this is typically, you'll see this type of information when we categorize offenses. So this is what we're showing here is this is a 10-year felony, and we provided the comparables that you can see there. And as you can see, all the other comparables that were provided are 10-year felonies, and they are also classified as category 4 offenses. So it is consistent based on comparables and the process that the commission does use in terms of setting seriousness categories.
Okay, thank you, David.
Sure.
Any other comments, questions? All right, is there a motion to accept the commission recommendation?
So moved.
Second? Thank you. All right, all in favor of accepting the commission's recommendation to recategorize the offense?
Aye.
David, do you have a vote? Count?
Yep, just give me 1 second.
Take your time.
I think I got it all. Okay, and Ms. Grenier, did you? Okay, thank you. I appreciate it.
Okay.
All right, I saw that.
All right, so all opposed?
Okay, and that recorded. So we have a clear majority in favor of the proposed reclassification.
All right, thanks so much. That concludes the guidelines subcommittee report.
Okay, thank you. So more of me talking, yay for everyone, but I appreciate it. So we'll move on to the executive director report. It's a little bit, I have 3 items to review today. And one of the first things that I wanted to do is just announce, I can't introduce him, he has class tonight, but I am pleased to announce that Mark Mills is joining the Sentencing Commission staff as a policy analyst. Mark is working 20 hours per week as a graduate research assistant. He's a doctoral student in the Department of Criminology and Criminal Justice at the University of Maryland, and we are really looking forward to his contributions. He's a little bit different he's not a typical graduate student. For the past 10 years, he has served as a deputy district attorney in Elko County, Nevada, and we are excited to welcome his legal experience to our staff, because I think that's a nice compliment for the current makeup of our staff. So we're happy to have him. This is particularly nice to report on because the position was taken away from us during COVID when we had to do a budget reduction. And so we lost funding for this position during COVID, and the funding was restored. So we're really happy to announce his appointment and hopefully have an opportunity to introduce him to you all at a future meeting when he doesn't have a class going on at the same time. The second item I want to report on is just the staff's continued sentencing guidelines training the staff is providing via online webinars. Most recently, we conducted 2 webinar sessions, one on July 28th and another one on September 8th. These 2 sessions were intended primarily for law clerks and for court staff. The trainings provide information on the background and goals of the sentencing guidelines, and they provide an overview of the guidelines calculation process and offered a demonstration of how to use the Maryland automated guidelines system, and also focused on describing recent amendments to the guidelines with a particular emphasis on the April 1, 2021 update regarding guidelines compliant pleas. Additionally, the Sentencing Commission website provides access to a webinar called Maryland Sentencing Guidelines 101, and this is a webinar that is available for anyone to view on demand whenever they would like to do so. And finally, I just want to share that the website also offers 2 Maryland Automated Guideline Systems, or MAGs, instructional videos that are also can be viewed at any time on demand. The last item that I want to report on is I listed in the agenda as a status report with requests for input. This is just to review the protocol for the December 7th public comments hearing. The Sentencing Commission's enabling legislation requires that the commission hold an annual public comments hearing. The hearing is important because it provides a forum for the public to discuss sentencing related issues. And the Commission's 2021 public comments hearing is scheduled for December 7th at 5 p.m. The meeting will be followed by a regular business meeting. Next month, a hearing invitation will be distributed to approximately 35 key criminal justice stakeholders throughout the state, and further, the invitation will be distributed to roughly 1,000 criminal justice practitioners that currently receive the Sentencing Commission's electronic newsletter, the Guidelines e-News. In addition, the hearing will be announced on the Commission's website and the Maryland Register and the General Assembly's hearing schedule and anywhere else that we can think of to post notice of it. We usually call on Secretary Green's press office to help us, and they've always been very kind in helping us to post it there as well. The hearing announcement will indicate that the event will be, live streamed. Hopefully we'll get that figured out by the next meeting and provide a link to access the live stream. There are a few other administrative items that I wanted to discuss and get feedback on regarding the protocol for the public hearing. First, at this point, we're hoping that we can conduct a hybrid in-person virtual meeting. If in-person meetings are possible in December, the meeting is on the schedule to be held at the Maryland Judicial Center. And our plan is to utilize a room that includes video cameras so we can record those that are in person and also allow for virtual participation. If something changes and an in-person meeting is not available to judicial, we can always convert it to a strictly virtual meeting via Zoom, just like we did last year. But we would probably need to make that decision in the beginning of November, so we would have time to publish an update regarding the meeting details in the Maryland Register as we were required to do regarding our public meetings. I wanted to ask if there are any thoughts on the proposed plan to proceed with a hybrid in-person versus virtual meeting with the option to switch to a strictly virtual if needed. I just want to see if anyone has any thoughts on that. If we should plan to proceed as a in-person with the hybrid, with the hybrid option. Just wanted to see if there's any input on that, or if we're not, we'll just plan to go ahead with that as the proposed plan. Okay, I don't see any objections to that, so we'll go forward with that. The next item that I wanted to request input on is whether the staff should begin the public hearing with a presentation. We did one last year at the beginning, and the purpose of that was really to provide a history, the purpose and goals of the sentencing guidelines and the Sentencing Commission. I provided a brief background presentation last year at the beginning and just wanted to get input on whether commissioners thought that was helpful and if we should plan to do so again.
I think it's useful. I think a lot of people don't really know what we do as a commission.
Right.
And, to the extent that you can do it briefly and kind of lay it out, explain what our purpose is. And I think that's pretty useful and a good way to start the meeting.
Okay, thank you. I appreciate that.
I agree with that. I found it very helpful last year when we did that.
Right. Thank you, Lisa. Okay, well, it sounds good. We will plan to do that. The last item that I thought I just is not really a question, but rather a request. I just want to encourage commissioners to think about thoughtful speakers who may be good to speak directly to the sentencing issues that are within the scope of what we do at the Sentencing Commission. I encourage you to reach out to them, and they feel free to tell them to reach out to me or Judge Avery or Judge Wilson or any of you to talk about it, but I'd be happy to walk them through the process and what they might expect with that. And so I just ask you to, if you can think of anyone, to please ask them to contact me, and we can arrange for them to speak at the public hearing. So that will conclude. Well, actually, sorry, I have one last announcement that I wanted to share. Before I conclude my report, I did want to excitedly share the news that our staff training coordinator, Catherine, who you all know she is currently on maternity leave. Her and her husband welcomed a new baby just a few weeks ago. And so she'll be on leave for the next couple of months, but we are very excited for Catherine and her husband to welcome a new baby boy to their family. And then on that note, that will conclude.
Commission, please convey our best wishes.
Yes, congratulations,
Absolutely.
Catherine.
Yeah.
Yes. Thank you. I appreciate that. I will definitely share that with her. And that will conclude my executive director report. Thank you.
All right, thanks so much. We've already established the November date.
Correct.
You talked about the public meeting. Is there any other business, old or new? All right, then I think that we've concluded. Welcome to all of our new members.
Shannon, I put my hand up.
Patty's got her hand up.
I see.
I thought I did
see.
the right thing. I thought I was following directions.
Thanks,
See
Judge
that
Lewis.
hand?
Thank you.
You get a
That's
gold
okay,
star, Patty.
Shannon. My name is Patty Lewis. I'm a district court judge. And at the last meeting, Senator Kelly very wisely stated that as we brought on more scholars to work with us, that it would be wise and considerate if we would open it up to some of the other colleges and universities, particularly our historically Black colleges and universities. As an adjunct professor at Bowie State, which is not far from Annapolis, actually technically closer than College Park, and adjunct professor there, I would simply say we have a wonderful criminal justice department in which I teach, and an excellent behavioral program. And I would highly recommend, and I'm happy, David, to be a conduit, in touch with Dr. Charles Adams and see if we can't. And I know that if Kelly were on the thing, she would be speaking about Morgan State with her long history there. But I'm just saying, I think it would be kind and thoughtful and appropriate to also expand some of the scholars who are allowed to work with us. And I do want every one of our staff to know I am more than pleased with all of the work, and it's nothing to do with that. It's just expanding opportunities. Make sense?
It does. Thank you, Judge Lewis. I agree. I think that's an excellent point, and I appreciate the reminder that Senator Kelly, that's an excellent point. I think that it is incumbent upon us to reach out to some of those, the HBCUs in particular, and see how we can incorporate their input and thoughts into the deliberations of the commission. So I appreciate that, and I will I'll reach back out to you since you did volunteer. And
Absolutely.
Thank you. I appreciate that, Judge Lewis.
Thank you.
That's great. Thank you, Judge Lewis, and thank you for speaking up, because I did not notice the little hand. Now I see it.
I don't know how to make it go away.
I think if you just click it again. All right, any other old or new business? All right, well, thanks. We are adjourned.
Thank you.
Thank you, everyone. I appreciate you all for joining. Have a great evening.
Bye-bye.